Ayeka TV so ni e beda mase ni ama obi bia akwa abade maba Ayeka TV so abusua mu nim se etena se sei de ensem a eye gentre ha ana se trend we o man Ghana mu ni titru politics and entertainment and boaboa no na e de ni nyina aba abesom da busua ene de ye bohwi ni ewurem a na ye kwa akopiem e wo ye Parliament House and then ehɔ na eye Alban Sumana Bagbin ebusia na ni abriye papa ne bu afu anya asem ketua na ene sen wase waka ne pen no obesa aka ne bi o kan sisu dua se eye amanfo bi pese o mo je eye parliamentarians no madwuma firi o mo nsam wase mu amoye saa de ni nyina no we ye notice ene wo de mamo na so wo bom kokko na asem ni nyina ne se wase eye asem a ye ka no parliament ana se parliament ho no eye mra ene ye hyehye wo ho no ntimi ye fro mo mra hye bedwafo no mo na hyehye mra wase eye adwuma wo Ghana ha sei no wase se omo ye in a process hyehye mra bi na eye president of the land eye na nado dankwa Akufo-Addo enyanje saa mra ne ntuma ene obi bia antam saa mra no ankopim wo court abusuan na ni abriye pa no ka saa semwe ntino wase onim se saa bill na eye attorney general ene ne nkofo atam dia kopiem wo court no ne de onim outcome no eye de judges ne beka e wo Supreme Court wo no but on person obeka ni CCA nemum notice ene wo de masa nkofo ni nyina wase so mo ka asem wo parliament wo no na se omunya nkan wie ana se president na nado dankwa Akufo-Addo enya mfa ne nsan hyase se so asemu ye aye parliamentarians yiken ye de beye mra ana se we de yembontungu a obi ani ho kwan so otimi edikopim e wo court abusuya asem ni nkire mu nyina wo hono yenko na yenkotie eye speaker of parliament Bagbin wa bra na ni abra otutuja no ndamase.
Please let it be known that when it comes to law making, until all the processes in this house are exhausted, there is no business for anybody, including the courts, to consider. Because the Constitution and the enabling legislation takes care of all these challenges. Until, if it is a law, it is assented to by the President, Judiciary has no jurisdiction to try to pry into it. This is notice. We have to take this seriously, or else our legislative authority is being taken away from us by other agencies and arms of government. That should be resisted by this house, or else your being here is of no consequence. The law is very clear on this. And so until a bill is assented to by the President, nobody has any business to take that process that is being considered by the House to the court. And I don't want to preempt the judgment of the Supreme Court in this matter. But I'm giving notice because on daily basis, I'm being served with writs as a party on matters that are being considered by the House. That's why I'm compelled to say this.
The question I wanted to ask all of you, but I thought I would hold on till I had heard from Parliament whether in our constitutional histories, from First Republic to Fourth Republic, we have had a private members bill such as this.
Especially, indeed, the situation is novel, and it occurred only in the life of the 7th Parliament, which was from 2017 to 2021. It was in that time that the Speaker, the former
in the very last Parliament.
The very last Parliament. Yes, that's the Speaker of Parliament, then Professor Michael Quay, quite innovatively encouraged the initiation of private members bill, and it was the first private members bill. It did not involve any charge of reserve fund at all.
Which was?
I forgot the time matter. I think was also a very controversial direct matter, and for that matter, it didn't really. But there was one such bill. I believe the Council for the Affairs for that may assist the court in that regard. The first bill was introduced in Professor Michael Quay's tenure as Speaker of Parliament. I think 2019 or so. Especially so, hitherto there was no such concern as to the implications of a bill for Article 108, because all bills emanated from the executive. So there was implied in the introduction of such a bill a consideration of the financial implications. And indeed, there was no concern, because the basis for the speaker to exercise, or the person presiding to make a determination, did not arise, because it was from the executive. But that is why I consider this point so important, that I think the court ought to be given an opportunity of determining the issue, whether indeed there has been an infraction of Article 108 or not. Because from 1957, the provision has been present in every constitution the country has had, apart from the 1961. And the 1960 was quite peculiar, as you said. It gave somebody a life president's status. So that's quite different. My preference, I would say, would be for the court to preserve the status quo, determine the question, and then if the determination is made whichever way, then the nation can move on.
Determine which question? Determine the question in the substantive suit?
No.
Or determine the question in this application?
No, determine the questions in the substantive suit.
The substantive suit.
So pending that, then there ought to be a preservation of the status quo for the court to be given an opportunity of determining. So clearly, it is only where the court considers the collective good of the nation. And I would say that in matters that border on withdrawals from the constituted fund or the use of the public purse, as I have with all respect demonstrated before you, the collective good actually will be in respect of holding the status quo, for the court to indeed determine whether the bill that is being sought to be, for want of a better expression, rushed, is in the public good or indeed affects the public purse. If the bill affects the public purse, then with all respect, the court owes a duty to halt the progress of that bill. I would also quickly address the point that this is actually not a case where the law in question is at its formative stages or going through the processes in Parliament.